Still on the Security Laws Amendment Bill, the Commission for the Implementation of the Constitution says it was not consulted in the drafting of the contentious Security Laws Amendment Bill. CIC Chairman Charles Nyachae says that they have warned the Executive and Parliament that the bill is unconstitutional. But where exactly does CIC find fault in the controversial bill? KTN'S Asha Mwilu now reports.
It's now caught the attention of global lobby groups. The proposed amendments bill to security laws has prompted Amnesty International and the Human Rights Watch to chime in. Both groups now urging lawmakers to reject the bill. While the executive shows no sign of blinking fast, the dissenting voices are also proving unrelenting.
You can see the goal is very deliberate. Return Kenya to the Nyayo state. Return Kenya to the Jomo state.
Tunasema sisi hatukubaliani nazo. Hao waandikaji habari lazima wapewe uhuru wa kuinvestigate na kueleza Wakenya ni nini kinaendelea ndani ya serikali.
Chairperson of the Commission for the Implementation of the Constitution, Charles Nyachae, says the debate needs a more sober approach.
We must draw a distinction between those provisions in the Constitution, in the proposed bill, which are unconstitutional. Yeah, and I've tried to give you some examples. We must draw a distinction between that and where Parliament, within the confines of the Constitution, is making certain decisions.
Nyachae says that while many are basing their arguments against the amendments on the Bill of Rights, Article 24 of the Constitution states that a right or a fundamental freedom can be limited by law. This can, however, only be done if all relevant factors are taken into account. These are the nature of the right or freedom, importance of the purpose of limitation, the nature and extent of the limitation, the need to ensure that an individual's enjoyment of rights and freedoms doesn't prejudice the rights of others, and the relation between the limitation and its purpose, and whether there are less restrictive means to achieve the purpose. CIC is, however, concerned that some of the proposed amendments are going against this article. For instance, in proposed amendments to the National Intelligence Service Act, the Director General of NIS can authorize any of his members to obtain any information, material, record, document, or thing, and for that purpose, search any place or obtain access to anything, search for and make copies of anything, monitor communication, install, maintain, or remove anything, or do anything considered necessary to preserve national security. Nyachae argues that while this blanket provision in the proposed amendment limits the right to privacy, it does not explain the nature or extent of the limitation.
You are creating an offense of publishing material that is obscene, that is offensive, that is gory. Now, I don't think, if we asked any of us, we would probably have different ideas of what is obscene, what is gory, what is offensive.
In the Prevention of Terrorism Act, the bill proposes an amendment to limit media coverage of terrorism. It proposes that any person who, without authorization from the National Police Service, broadcasts any information which undermines investigations or security operations relating to terrorism commits an offense and is liable to either 3 years in jail, a fine of 5 million, or both. In this case, the nature and extent of limitation to freedom of the media and freedom of expression has not been clearly explained. Article 25 of the Constitution clearly stipulates the rights and freedoms that may not be limited in any circumstance. Those are freedom from torture and cruelty, inhuman or degrading treatment or punishment, freedom from slavery and servitude, right to a fair trial, and right to have your detention justified in court. But in the Criminal Procedure Code, a proposed amendment give the prosecution leeway to not disclose certain evidence on which it relies if that evidence, among other provisions, may facilitate the commission of other offenses or is sensitive and not in public interest. Nyachae says that if that amendment is approved by Parliament, it goes against the Constitution, which guarantees an individual the absolute right to a fair trial.
If the bill is published as is, it clearly contains unconstitutional provisions, and we would have no choice but to seek judicial intervention.
With the controversies surrounding the Security Laws Amendments Bill, CIC wants Parliament to review some of the amendments on the floor of the House and warns that even the mere lack of proper public participation can render the bill unconstitutional. Asha Mwilu, KTN, Nairobi.